Welcome back, ladies and gentlemen, to another episode of the Law with Darren podcast. Today, I would like to talk about, if you guys watch the news today, you see people robbing stores and literally walking into Apple stores and Best Buys and cutting cords and walking out with products. And it made me think about a certain law that we talked about in law school, something that's known as the shopkeeper's privilege. What exactly is that? Well, today I'll be going over Rhode Island's version of that first. The shopkeeper's privilege, basically, in Rhode Island, is actually written in the law itself. What it is, it's Rhode Island General Law 114121. And it's a part of the criminal offense statute. So this is the same area that covers theft, embezzlement, false pretenses, and misappropriation. So this is serious. And what the Rhode Island law says is this. First of all, it says any person reasonably believed to have committed or to be committing the crime of shoplifting shall be subject to detention by a police officer in accordance with another law. But here's the good part. Section B. Any merchant who observes any person concealing or attempting to conceal merchandise on his person or amongst his or her belongings or upon the person or amongst the belongings of another, transporting merchandise beyond the area within the retail merchandise establishment where payment for it is to be made without making payment for it, or removing or altering price tags on merchandise, or switching the containers of merchandise may stop the person. So right off the bat, the statute is telling us that merchants, if they believe that someone has done any of those things, they may detain the person. But the opening line, though, says any merchant who observes, and that's important later on. The statute then goes on to read, if, after his or her initial confrontation with the person under suspicion, the merchant has reasonable grounds to believe that at the time stopped, the person was committing or attempting to commit the crime of shoplifting on the premises, the merchant may detain the person for a reasonable time sufficient to summon a police officer to the premises. Period. In no case shall the detention be for a period exceeding 1 hour. Detention must be accomplished in a reasonable manner without unreasonable restraint or excessive force, and may take place only on the premises of the retail merchandise establishment where the alleged shoplifting occurred. So basically, you can't just take them somewhere else and try to interrogate them. Once placed under detention, no other information shall be required of the person, and no written and or signed statement, except as provided in subsection C, which I'll cover, shall be elicited from the person until the police officer has taken him or her into custody. The merchant may, however, examine, for the purposes of ascertaining ownership, any merchandise which is in plain view, so you can't go searching the person, which the merchant has reasonable grounds to believe was unlawfully taken or otherwise tampered with in violation of the statute. So there's a lot to cover there. We could break the statute down, but it's pretty simple. Basically, if you're a merchant and you actually observe somebody shoplifting, you have the right under law and protection to detain that person while you call the police. But you can't detain them for 2 hours and then call the police. You have to detain them right away, call the police right away, and the detention itself shall not be for more than an hour. Another interesting aspect of this was that, the merchant, shop owner, whoever, can actually search or examine any merchandise which is in plain view, which the merchant has reasonable grounds to believe was unlawfully taken. So if they're walking around with a bag on their person, I suppose that means you could, ask them to let you look at the bag, which we see a lot in these YouTube videos. So, it's a pretty simple statute. It does give people, it does protect merchants. So long story short, if you're going to shoplift, which you shouldn't be doing. But if you're a merchant and you see somebody shoplifting, you can, in fact, detain that person. Now, why is that not happening in California? And I don't know California law, but my suspicion is that even though the statute allows merchants and store owners to detain people, you can't just tackle them, right, as they're walking out of the store and potentially injure them and break their spine. I mean, I suppose you could, and then they would, the shoplifter would hire a lawyer to sue the store and then go to a jury. I wouldn't give them any money. I don't have much sympathy for shoplifters, but that's just my opinion. So, hope you guys enjoyed the episode. It's a short one today. I'm going to try to keep it short. If you have any questions, feel free to comment in the areas below, and I will try to answer any comments. I do want to cover, there was one case that did cover this area of this incident of observation. It's the case of Cruz versus Johnson. It's a 2003 Rhode Island case. The citation 2003, Rhode Island, Lexus 156. Basically, in that case, these two women go to a Stop and Shop over in Pawtucket, and one of the women is shoplifting, but her friend that she's with is not aware that her friend is shoplifting, and a security guard goes after the woman who was with the shoplifter but was not aware her friend was shoplifting, and that security guard detains her. And the case was ultimately decided on the grounds that because the security guard did not actually observe the innocent woman shoplifting, that basically he had made a mistake. And the woman's case against Stop and Shop and the security guard was able to go forward. So, hope you guys enjoyed the episode. Again, I'll try to cover Massachusetts and Connecticut next. I know they have similar statutes. Have a good day. Take care and be well.